In a time of deep political division, a unanimous Supreme Court decision stands out as a rare moment of clarity. The case of National Rifle Association of America versus Vulo wasn't just about one group, it was a powerful stand for free speech everywhere. The ruling addressed a subtle form of censorship, when government pressures private companies to silence voices it dislikes. This principle is vital for any free society, protecting not just popular speech, but also the speech we find uncomfortable. The decision's impact is global, setting a clear standard for courts and activists worldwide. It's a reminder that government cannot use its power to financially cripple or silence advocacy groups or citizens for their viewpoints. This story explores how this landmark case reshaped the boundaries of free expression and government power. The roots of this explosive legal battle trace back to New York, a state often at the center of national debates over rights and regulation. Here, Maria Vulo, then the state's top financial regulator, took decisive action in the wake of the tragic Parkland school shooting, which had reignited fierce arguments over gun control across the country. Vulo didn't just issue statements, she actively pressured banks and insurance companies to reconsider their business with the National Rifle Association, warning them about potential reputational risks if they continued those relationships. Some insiders claimed she even hinted at regulatory leniency for those who complied. This wasn't an outright ban on the NRA, but a calculated squeeze. The message was clear. Doing business with the NRA could bring trouble. Fearing public backlash and possible regulatory headaches, many companies quickly severed their ties with the group. The NRA responded by filing a lawsuit, arguing that Vulo's campaign amounted to government censorship by proxy, punishing the organization for its political views and advocacy. The legal battle quickly escalated. Lower courts were divided. A district court allowed the NRA's case to move forward, recognizing the potential threat to free speech. But the appeals court saw things differently, dismissing the case and ruling that Vulo's actions were simply permissible government speech, not unconstitutional coercion. This raised a profound question: can any government official use their power to pressure private companies into blacklisting organizations based solely on their advocacy or beliefs? Where's the line between persuasion and coercion? With the stakes so high, the stage was set for the Supreme Court to weigh in. Was this legitimate regulation, or did it cross the line into unconstitutional coercion and suppression of free speech? The court's answer would not only decide the fate of the NRA in this case, but also set a powerful precedent with sweeping consequences for the future of free speech and government power in America. On June 29, 2024, the Supreme Court unanimously sided with the NRA, reversing the lower court's decision. Justice Sotomayor wrote that while officials can express opinions, they cannot use threats to suppress speech. The court found Vulo's actions plausibly coercive. Her guidance, meetings, and offers of leniency crossed the constitutional line. The ruling didn't end the case, but set a strong standard. Government can't use its power to intimidate third parties into silencing speakers. The 9-0 decision, joined by justices across the spectrum, underscored that protecting speech from government intimidation is foundational. Civil liberties groups, including the ACLU, celebrated the ruling as a defense for all advocacy, regardless of viewpoint. The message was clear. The First Amendment protects everyone's right to participate in public debate, free from government coercion. The Vulo decision's impact was immediate, sending shockwaves through both legal and media circles. It wasn't just a victory for gun rights advocates, it set a powerful precedent for how government officials could interact with private companies, especially when it came to matter of free speech. This new legal landscape was quickly tested by a fresh controversy involving the popular late-night show, Jimmy Kimmel Live. After Kimmel delivered a biting monologue criticizing President Trump, the show found itself at the center of a national debate over the limits of government influence on the press. FCC Chairman Brendan Carr publicly warned broadcasters, hinting at possible threats to their licenses if they continued to air content critical of the administration. The warning was subtle, but its intent was clear. President Trump amplified the threat, suggesting that stations airing such critical content could face the loss of their broadcasting licenses. A move that sent a chill through the industry. The chilling effect was swift and unmistakable. Executives and producers across the country began to question whether airing controversial content was worth the risk. Major station owners quickly dropped Kimmel's show from their lineups, and ABC suspended it altogether, fearing regulatory retaliation and the potential loss of their broadcasting rights. the parallels to the Vulo case were unmistakable. Once again, government pressure was leading private companies to silence a critical voice, not through direct censorship, but through veiled threats and regulatory intimidation. This kind of government pressure, even when indirect, had the power to make private companies act as censors, stifling dissent and debate. The Supreme Court's ruling in Vulo became a crucial shield, offering legal protection to those who might otherwise be forced into silence by government intimidation. Broadcasters and civil liberties groups now had a clear legal basis to challenge the administration's actions and to defend the independence of the press. The case demonstrated that even veiled threats, those that stop short of outright bans, can chill speech just as effectively, creating a climate of fear and self-censorship. The battle over Kimmel's show became the first real-world test of the Vulo standard, putting the Supreme Court's new precedent to the test in the high-stakes world of national media. It raised the stakes for the future of free speech and a free press in America, highlighting just how fragile these freedoms can be when government power is wielded carelessly. The precedent now protected not just advocacy groups and activists, but the entire media landscape, ensuring that the voices of journalists, entertainers, and critics alike could not be silenced by government threats, no matter how subtle. The Kimmel controversy is a powerful example of the chilling effect, when the mere possibility of government retaliation causes people to hold back their opinions or censor themselves. This isn't just about one person or one organization, it's about the broader impact on society when fear replaces open dialogue. Officials don't always need to ban speech outright. Sometimes simply creating an atmosphere of intimidation or uncertainty is enough to silence critics. Subtle signals, veiled threats, or even a strongly worded letter can send a message that speaking out comes with consequences. The Supreme Court has recognized that when a powerful official suggests a course of action, it's rarely just a suggestion. For those on the receiving end, it often feels like a direct threat, especially when livelihoods or reputations are on the line. The economic stakes in these situations can be enormous. For the NRA, losing access to insurance partners wasn't just a setback. It threatened the organization's very survival and ability to operate. For media outlets, the loss of a broadcasting license or key financial support could mean financial ruin, forcing them to shut down or drastically cut back on their reporting. Companies, which are often risk-averse by nature, tend to choose compliance over engaging in costly legal battles. This leads to a narrowing of public debate, as fewer voices are willing to take the risk of speaking out. Ultimately, the real victim is the public. As critical voices disappear and the range of ideas shrinks, society loses access to important perspectives and information. The Vulo decision reaffirmed that the First Amendment demands a true marketplace of ideas, one that is free from government coercion, intimidation, or manipulation. This protection ensures that the public can hear a diversity of viewpoints, not just those the government finds acceptable or convenient. It's about preserving the right to challenge, to question, and to debate. Without these protections, democracy itself is at risk, because a democracy without free and open speech is no democracy at all. Legal experts across the spectrum hailed Vulo as a landmark for free speech. The ruling's unanimous nature provides a nonpartisan shield against viewpoint discrimination by government actors. Vulo builds on past precedents like Bantam books, updating them for today's complex regulatory landscape. The decision clarifies that using regulatory leverage over banks or insurers is modern-day censorship by proxy. It also reins in the power of administrative agencies, reminding them their authority has limits. Courts now have a tool to scrutinize the motives behind regulatory actions, ensuring agencies can't punish speakers they dislike. The Vulo precedent will shape future cases involving speech on the internet, social media, and financial services. The message government can't outsource censorship. Constitutional protections follow its power, however indirect. The principles in Vulo matter for everyone, not just big organizations. Consider Kilmar Abrego Garcia, mistakenly deported to El Salvador despite a judge's order protecting him. Bureaucratic error and government inaction put his life in danger, showing how unchecked power can devastate individuals. His case reached the Supreme Court, which allowed a judge's directive to stand, highlighting the judiciary's role in checking executive power. Senator Chris Van Hollen summed it up. The government acted swiftly to deport, but drags its feet to correct its mistake. Abrego Garcia's ordeal is a stark reminder. Behind legal principles are real lives at stake. The court's willingness to intervene is crucial for accountability. The fight against overreach is not abstract. It's about justice for every person. The limits of executive power extend to the economy, as seen in President Trump's use of emergency powers to impose tariffs. By declaring national emergencies, the administration bypassed Congress to tax imports, sparking a major legal challenge. Lower courts sided with challengers, finding the president exceeded statutory authority. The Supreme Court was asked to decide if regulating trade equals taxing it, a question with huge implications for separation of powers. Legal experts predicted another strong rebuke, citing the major questions doctrine. Major policy shifts require clear congressional approval. The case fits a broader pattern, the court acting as referee between executive ambition and constitutional limits. The message: even in national security and trade, the president must operate within the law. The Supreme Court's unanimous decision in Vullo is a victory for free speech, not just for one group, but for all. It draws a clear line. No official can use their office to silence voices through coercion. The events that followed, from media pressure to corporate self-censorship, show why this precedent is vital. Vullo empowers everyone, media, advocacy groups, individuals, to challenge intimidation and defend open debate. The responsibility to protect these freedoms belongs to all of us, not just the courts. We must remain vigilant against subtle censorship, insisting government protects, not polices, speech. The First Amendment's strength is measured by its defense of unpopular speech. The Vullo ruling is a call to action: defend free expression, so the light of democracy never dims.